Congress just passed the Corporate Transparency Act to require beneficial ownership disclosure. Does it affect you? Let's find out right now. Hi, I'm William Dolan, and this is Esquire Advice, where we explain complicated and lucrative real estate and business topics. Remember, we are not forming a lawyer-client relationship by way of this channel. Always consult your local attorney before taking any action. With that said, grab a pencil and a piece of paper and get ready to learn. Welcome to our episode on the Corporate Transparency Act to require beneficial ownership disclosure. But before we get started, please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. The reason this act is such a big deal is that privacy is important to many people for a variety of reasons. One of many reasons Delaware LLCs are so popular is because the identities of the beneficial owners and managers of their LLCs are not public information. In fact, they are not provided to the state of Delaware at all. Many other states require that the name and address of the members and/or managers of the LLC be provided and even made public. In comes the Corporate Transparency Act to require beneficial ownership disclosure. Now, the act is not effective until the Treasury Department adopts regulations for it. These regulations are important because they will fill in some important details and give us answers to questions that we just don't know right now. The regulations must be adopted by January the 1st, 2022, so the act should become effective later this year or early next year at the latest. The purpose of the act is designed to help enforcement agencies combat terrorism and money laundering schemes, which have used business entities to hide the identity of their owners. Once effective, existing businesses will have 2 years to file and report their owners' information to the U.S. Department of the Treasury's Financial Crimes Enforcement Network. Changes to ownership will need to be reported too. The act expressly applies to corporations, LLCs, and similar companies. There are still some questions as to whether the act will apply to trusts, sole proprietorships, and subsidiaries. There are some companies that will be exempted. For example, companies that are publicly traded or highly regulated by other governmental agencies like banks and insurance companies, and also companies that employ more than 20 people, file a tax return with gross receipts in excess of $5 million, and have a physical presence in the U.S. You must have all three of those conditions. If so, the exemption will apply. This last exemption will only work on the front end, as once the act is effective, a new company cannot have a prior year tax return. There will also be a 25% ownership or control threshold that still needs to be detailed. The information that will need to be reported is the full legal name, the date of birth, current residential or business street address, and a unique identifying number like a driver's license number or a passport number. The information will be stored in a private database and will not be accessible to the general public. It will be available to federal law enforcement agencies and, with court approval, other law enforcement agencies too. Failure to report complete or updated information is subject to a daily civil penalty of $500 and criminal fines of up to $10,000 and/or a maximum of 2 years in prison. I hope you have enjoyed this episode on the Corporate Transparency Act to require beneficial ownership disclosure. Please kindly hit those like and subscribe buttons so we can keep bringing you valuable and profitable content. With that said, thanks for watching, and I'll see you next time.